Please, my Lord Deputy President and my Lords, I appear on behalf of the appellant with my learned friends Mr Cottrell and Mr Westwell against my learned friend Mr Stevens of King's Counsel, leading Mr Clegg and Mr Saxby. My Lords, this appeal is concerned with the question as to what fairness requires of a court when it's presented with written expert evidence on a central issue in a claim, here that of causation, where A, the factual basis upon which the expert evidence was provided is established at trial, B, there is no factual evidence in conflict with the expert evidence, C, there is no expert evidence in conflict with the expert evidence adduced by the claimant, and D, the other side did not seek to challenge the opinion evidence of the expert by requiring the expert to attend trial for cross-examination. In other words, where what we call the expert evidence is uncontroverted. The position taken by the majority in the Court of Appeal is set out by Lady Justice Aspin at paragraphs 60 to 67, and can I invite the Court please to turn up page 132. Paragraph 60 is in the middle, and Lady Justice Aspin starts off, "What of fairness?" and answers it by stating that what we call the rule in Brown and Dunn is, and if you kindly go over the page to paragraph 62, beginning of paragraph 62, not relevant here. That's because it is, per Lady Justice Aspin's next sentence, a rule which is concerned with challenges to the truth of the witness evidence. See how she says on the basis that it is untrue. The consequence of which can be seen at paragraph 65, which is first sentence, there is nothing which is inherently unfair in seeking to challenge expert evidence in closing submissions. And if you then drop down about 6 lines, you'll see it starts, so about 6 lines, the court can see, as long as the expert's veracity is not challenged. Does the court have that? As long as the expert's veracity is not challenged, a party may reserve its criticisms of a report until closing submissions, if it chooses to do so. So that, see paragraph 67, page 134, right in the middle, as part of a fair trial, does the court see that right in the middle? It seems to me that it was essential that Judge Truman engage with those submissions and determine whether causation had been proved to the requisite standard. In other words, fairness comes into the equation only in establishing that the trial judge is required to engage with submissions criticising the quality of the reasoning of the expert so as to decide whether the burden of proof has not been satisfied, and so, as a consequence of that, rejecting the expert evidence. See the next, or 2 sentences down in para 67. She had cogent reasons for deciding that the burden of proof in relation to causation had not been satisfied, and rejected Professor Pennington's report accordingly. So it does not lack for clarity, the analysis of Lady Justice Aspin. One can see exactly how she has approached the issue before this court.
I'm slightly struggling with the notion that the judge didn't decide that the professor was wrong. I mean, the professor said,
my Lord, it's the first submission.
Balance of probability, causation was established, and the judge said, no, it wasn't. Why wasn't there finding that the professor was wrong?
It's my first submission I'm going to make because it seems so important to get that out in the open, because this has, in our respectful submission, gone down a wrong track from the off. But I will, if I may, make that submission further, but certainly, my Lord, that is the position from the appellant's perspective.
Yes, I mean, this case raises important issues, but I should alert counsel that the panel is slightly surprised that one needs a day and a half for it. And I would ask counsel to bear that in mind.
Absolutely, Model. Earlier comments across the bench were to the effect that I was delighted that we'd been given a day and a half, but didn't expect that it'd be one of those days when I was being sweated minute by minute to get through my submission.
No, you've been given that time, so it's not been withdrawn from you, but our impression, having read the material, is that we can probably cover it in a shorter time.
But yes, I wouldn't say that was your Lordship's mistake, but when you give us the time, we tend to use it. But we do take the point, my Lord, and we'll seek to behave.
But yes, your point you were going to come to,
yes,
which I do understand, is that it is hard to consider that the judge was holding other than the expert was wrong.
Absolutely. It's entirely straightforward in our retrospective submission, which equiparates to accept or reject. Accepting or rejecting evidence is the same as saying it's right or wrong for these purposes. Our case, respectfully, is to take issue with every step of the analysis that I've just sought to set out. And as this court knows, there is a powerful dissenting judgment from that most moderate of judges, Lord Justice Bean, who was moved to describe at paragraph 99 at page 140 his profound disagreement with the approach taken by Lady Justice Aspin, that she could see nothing inherently unfair in bypassing cross-examination in favour of criticism by way of closing submission. So the appellant's case in short order is as follows. First, where a party wishes to challenge the evidence of the other party's witness in closing submissions, then generally that party needs to cross-examine that witness. And that is the so-called rule in Brown and Dunn. Secondly, the rationale of the rule in Brown and Dunn is fairness. More specifically, fairness to the witness, fairness to the party calling the witness, and fairness to the court. Thirdly, apologies if I'm going too fast, the rule in Brown and Dunn applies generally in civil claims, brackets, also criminal claims, but that doesn't matter for these purposes, not just to witness evidence of fact, but also to expert evidence, and not just where the challenge is to the truth of what the witness is saying. Fourthly, being a rule based upon fairness, the rule in Brown and Dunn is to be applied flexibly, and so where the evidence is incredible, it can be rejected by the court on paper, that is, without the witness being cross-examined. The incredible threshold is a high bar, equivalent in a case such as this to reverse summary judgment. Otherwise, one party can attack the reasoning of an expert by the other party whilst avoiding the uncomfortable reality that the expert may, when questioned, provide a complete explanation or answer to the criticisms levelled at his or her reasoning. And were the bar set lower, the party seeking to challenge the expert opinion evidence, as we would call it, by stealth, by closing submission, would be guilty of the conduct described by Alexander Pope, as quoted by Mr. Justice Wells in an Australian case I'm going to go to in due course called Reed and Kerr, as those who were willing to wound and yet afraid to strike. And the reference for that is page 642, but I will go back to it later, there's no need to go to it now. Fifthly, when applying the rule in Brown and Dunn to this case, not only is the rule clearly engaged, but it is a paradigm for its application, given the following. Professor Pennington gave clear evidence on the central issue in the case, namely causation. There was not any cross-examination of his evidence. As we'll see in due course, there are cases in which a witness has been cross-examined, but the higher courts have still held that the rule in Brown and Dunn has been offended because he wasn't cross-examined sufficiently in relation to the specific point that the judge later held was critical to his or her assessment. And his evidence was not otherwise controverted in any other way. Further, there is no suggestion that his evidence was incredible or that the respondent could have obtained reverse summary judgment. And the effect being, as Lord Halsbury put it in Brown and Dunn, page 308, we don't need to go there at the moment, that the defendant is taken by the absence of cross-examination to have admitted his evidence. That's the effect. The effect is the party electing not to cross-examine central evidence that is uncontroverted is taken to have admitted that evidence. My Lords, I propose to make submissions under the following headings. And first I was going to address the very issue that my Lord Briggs has already raised, which is the trial judge rejected the opinion evidence of Professor Pennington, that is, held that it was wrong, because it is an important point to get out early doors. And then I seek to develop in line of both our written case and the submissions I've just made. So the rule in Brown and Dunn is a rule of fairness, is my second submission or heading. The third heading is the rule is one of general application in civil litigation. I'll repeat these when I come to it, but just so the court understands where I'm hoping to go. The fourth is that the rule is to be applied flexibly and the court's entitled to reject expert opinion evidence without cross-examination where such evidence is incredible. And the fifth is how the rule applies in this case and how fairness requires the court to adopt the opinion evidence of Professor Pennington supporting the claimant's case. So may I then turn to that first issue, that of the trial judge did reject the opinion evidence of Professor Pennington. And it's an important issue because the respondent in its written case says, amongst other things, that the rule in Brown and Dunn is not engaged in this case because the court was not even invited to reject the relevant expert evidence, only to find that the claimant did not discharge the burden of proof. And so by this route, per the respondent's case, the rule in Brown and Dunn is effectively sidestepped. The appellant's case is as follows. Professor Pennington expressed a clear opinion on causation and provided a chain of reasoning express and implied that led to his conclusion. The trial judge held, and here can I invite you please to go to page 181, paragraph 28, which is in the middle. 3 lines down, please, in para 28, page 181, where the court can see, I am not satisfied that the medical evidence shows, following Wood and TUI, that it's more likely than not that the claimant's illness was caused by ingesting contaminated food or drink supplied by the hotel. And this was because there were gaps in the reasoning of his evidence. See 2 lines down at para 28 and the rest of the tenor of paragraph 28, which was set out, as in the purported gaps were set out in more detail at paragraphs 18 to 22 earlier. That's the essence of it. Not satisfied that the claimant has discharged the burden of proof for want of reasoning, if I can reduce it to that. She says also at paragraph 28, if you go right into, well, almost the middle, you'll see a sentence starting, the court is not a rubber stamp. Does the court see that? The court is not a rubber stamp to just accept what someone has said. And I wish to emphasise the word accept in that context. Instead, she held paragraph 30 when she drew the threads together. In the circumstances, this is page 182, I find the claimant has not proven his case and I dismiss the claim. But in a case where the judge considers that the expert's chain of reasoning is insufficient to support his clear conclusion, then necessarily the judge is holding that the expert's opinion should be rejected, or as Her Honour Judge Truman put it, not accepted, because one is the converse of the other. Or put another way, that the expert's opinion is wrong. And this is exactly how cases have approached this issue where the court's faced with uncontroverted expert opinion. The court's assessment in such cases is binary, to accept or to reject the evidence, where rejection necessarily means that the expert opinion is being held by the court to be wrong. After all, in this case, what we have is an opinion from Professor Pennington saying, in essence, causation is made out. There is a causal link between the gastric illnesses and the ingestion of food and drink at the hotel, which completes the claim on causation and establishes the breach of contract following Wood and Toohey. So the claim is made out, and the claim failed. And it can only fail because the judge rejected the expert opinion. There's no other route to victory for the defendant.
I'm slightly puzzled by the judge's reasoning that where there are more than one possible causes, you can't satisfy the burden of proof for cause A unless you exclude B and C, where all you're saying is that cause A is the more probable.
My Lord, yes. Part of the problem arose because of dicta in Wood and Toohey, and Wood and Toohey was the case that established that food, eating of food triggers the supplying goods and services implied term in relation to property, and that property is passed and it has to be of satisfactory quality. And then there are dicta from then Lord Justice Burnett and Sir Brian Leveson to the effect, as the learned judge said here, that you need to consider and exclude alternative sources. In the High Court, Sir Martin Spencer J. addressed these issues and accepted the submissions that the claimant had made to the effect that there was a difference between cases such as Wood and Toohey, where the guidance was given in relation to qualitative assessments, and cases of quantitative assessments, and I'll give you the reference for this. If you kindly go to page 162, paragraph 21. Paragraph 21, sorry, page 162, para 21. The dicta, which are actually, I think, will probably be set out in the judgment somewhere, but otherwise we can just go to them in the actual case. The dicta were considering a case where you don't have expert evidence, and essentially you have to do it by numbers. So if you have no expert evidence and you say one person was ill in a hotel that had a lot of people staying at it, and just one person of hundreds of people were ill, it'd be quite hard to prove your case. If you have an outbreak and you say 500 people were ill, it's quite straightforward for the court to make an assessment that the common denominator may well be the food at the hotel when on an all-inclusive package. And that's the sort of case that the Court of Appeal were giving their observations in relation to. But what they weren't doing is addressing a case that Mr. Justice Martin Spencer called a qualitative case, which you can see in the middle of paragraph 21, where the claimant relies upon appropriate expert evidence. And he confirms that that's how he analyses this case at paragraph 31, down at the bottom of page 166. And so That, in our respectful submission, is how Her Honour Judge Truman had been led astray, because she'd been led astray by the guidance given in a different context in Wood and Tyree, which we sought to put right on the first appeal to the High Court successfully, and wasn't a point then taken by the then appellants in the Court of Appeal. It's re-emerged in the Supreme Court, reference to Wood and Tyree, but it made no real appearance in the Court of Appeal, as I recall, at all, because the point had been disposed of at the High Court level.
I'd be grateful at some stage in your submission if you take us to the relevant passages in Wood and Tyree and explain why they can be distinguished.
Yes, my Lord.
Thank you.
Lord, yes. I mean, I can. Maybe I do it in reply, or I will show you now. If you go to page 595. Paragraph 29, starting at C, now in the judgment now of Lord Justice Burnett. In a claim for damages of this sort, the claimant must prove that the food or drink provided was the cause of their troubles and the food was not satisfactory. And then if you kindly sort of skim read down, you'll see, proving an episode of this sort was caused by food which was unfit is far from easy. It would not be enough to invite the court to draw an inference from the fact that someone was sick. Contamination must be proved, and it might be difficult to prove that food or drink was not of satisfactory quality. That's all it's said.
Yes, but this is all in the context that the evidence was deployed at trial in that case, that the hotel was applying standards of hygiene. Paragraph 30.
My Lord, yes. Yes, there was evidence in relation to standards of hygiene in that case, because you can try to establish your case by numbers, you can try to establish your case by reference to hygiene issues, you can try to establish that was a case in which hygiene issues were understood to go to breach before Wood and Tyree established that essentially you don't need to establish breach. If you establish causation, breach follows. That's the effect of Wood and Tyree. If you establish that your illness was due to contaminated food, ergo contaminated food is not of satisfactory quality. And so what's needed post Wood and Tyree, one route for a claimant, is simply to adduce expert evidence that the illness of which the claimant complains was caused by contaminated food. And if they establish that contaminated because it's got something like Giardia in it in this case, and if they establish that, the whole claim succeeds. And then what else we get is, if you go over the page at 596, paragraph 34, we're now in a very short judgment of the President of the Queen's Bench Division, in which he says, neither do I accept the floodgates argument which Mr. Alders advanced. I agree it will always be difficult, indeed very difficult, to prove an illness as a consequence of food or drink which is not of a satisfactory quality, unless there's cogent evidence that others have been similarly affected and alternative explanations would have to be excluded. And that's the source of the point that Her Honour Judge Truman was seeking to take. And that's what I addressed before Mr. Justice Martin Spencer, and that's what he dealt with in the 2 paragraphs that I've taken the court to. And so in our respectful submission, exactly in line with the observation of my Lord Briggs, the position is simply as follows. If an expert says the illness has been caused by contaminated food and drink, ergo it's not being caused by other matters. That is inherent within that expert opinion.
Or at least less likely to have been. I mean, bearing in mind we're in the territory of probability.
Well, my Lord, yes, but always to avoid the Popeye trap of the least unlikely. When he makes an assessment, which is necessary, that the illness has probably been caused by, once we overcome the threshold of probability.
An exclusion of alternative causes just means it was probably not caused by those.
Absolutely,
yes,
exactly.
No more than that. You don't exclude in the sense impossible.
Oh, no, absolutely, my Lord, exactly. But it is inherent within an assessment that it's probably been caused by X, that it has not probably been caused by Y, Z, or any other.
Well, it's probably caused by eating contaminated food or drink, but not necessarily the food or drink in the hotel.
Oh, sorry, it's a full opinion he gives that it's from the hotel. Yes, absolutely. It's a necessary part of the case, because otherwise it could have been food or drink from someone else.
And for the attribution of the contaminated food to the hotel, the expert, in response to the later questions,
Yes, my lord.
emphasised frequency, the fact that the claimant was eating most of his meals
Absolutely.
in the hotel.
Absolutely.
Yes.
And was there evidence available to the judge in any event that the hotel didn't apply hygienic standards?
It was sort of evidence by omission, in that the defendant had adduced witness evidence that they didn't call their witnesses.
Yeah.
So there really
But there was evidence from the claimant.
there's evidence from the claimant. There's witness statements your lordship's seen.
Yeah.
Yes.
Absolutely.
And the claimant's wife, I think, simply adopted certain
To
paragraphs,
similar effect.
including those paragraphs of his evidence.
Absolutely.
And that's been believed.
That has been believed, my lord.
Yes.
Can I just be clear? Is there any evidence, and what do you say about it, about impact on other guests at the time?
Yes, my lord. There was no evidence, as I understand it, adduced that this was not the 500 other guests case. And the issue was then raised with Professor Pennington in one of the questions, and he explained, I'll just find it. Yes, I think it's question 7. It's page 233 is the answer, and the question is 211. So question 211 is the question 7. If the court finds as fact that others on this holiday who'd consumed the food provided at the hotel were not similarly afflicted, to what extent would that impact on the opinions you express in relation to causation? His answers at page 233. A great majority of cases of foodborne infective gastroenteritis are sporadic and do not occur in outbreaks. So if no other cases similarly affected had been reported, this would not affect my conclusions regarding causation.
Can you just take them to his evidence, Catherine, please? Yeah, sure.
Yes. Yes. My learned friends encourage me to take you to page 1602. And this is, as he rightly says, this is hearsay evidence in that this is one of the witnesses who was not called for the defendant. And it's paragraphs 13 and 14.
12 and 13.
12 and 13, I'm sorry, where you get some numbers. 3,200 guests over the relevant window, some other reports.
How can that be relevant if it wasn't before the judge?
Well, can I perhaps let my learned friend address you later on those
Yes,
issues?
I think that will come in.
I think that will come as part of my learned friend can make it.
Yes, at the end of the day, we have to rely on what evidence there was before the judge to assess the judge's decision.
And as I recall, Honour Judge Truman herself notes how Mr. Clegg had said that this said words to the effect of, but I understand that you may not be able to take this evidence into account, and I can probably find the reference to that in due course.
Yes.
So in relation to this issue of how the court's approach is binary, you accept or you reject.
It was page 174, paragraph 5.
Oh, well, I'm extremely grateful. Thank you very much. So much easier than me trying
At
to
the
find
end of the paragraph.
Yes. That's exactly it. Can I just take the court to some cases in which we can see the language employed by the court? The first is the Cooper's Payen case. If you can kindly go to page 341. 341. This is a case in which there was a jointly instructed expert who was examined and cross-examined. You can see that at 342 on paragraph 50, but in which there is an observation from then Lord Justice Clark at paragraph 42, 341, down at the left-hand column at the bottom, going over to the next page, in which he says, for example, the joint expert may be the only witness on a particular topic, as for instance where the facts on which expresses an opinion are agreed. In such circumstances, it is difficult to envisage a case in which it would be appropriate to decide the case on the basis the expert's opinion was wrong.
Sorry, which paragraph? I do
My Lord, it's 40, para 42, page 341.
Right.
And it's the bottom left-hand column going just up into the right-hand column.
Yeah, sorry, what I was throwing, because I think you said going on to a different page, but it's the left-hand column going to the right-hand column. Thank you.
Yes, that's my fault.
Not at all.
And I'm just showing you that what we're going to see is repeatedly the language of which the courts employ in this sort of scenario is not the claimant or the party wouldn't have discharged the burden of proof. It's an assessment by the court to accept or reject or say right or wrong in relation to the uncontroverted expert evidence. If you can then go, please, to page 931. 931. This is a family case in which Dame Elizabeth Butler Schloss, President of the Family Division, was herself considering these sorts of issues. And between B and C, she says, in a case such as this, where the expert evidence, and here the expert evidence of the radiologist was all one way, the judge is certainly entitled, if he's evidence that he can rely upon to the contrary, not to accept that evidence. In my view, didn't have that evidence in this case. He did not, in particular, have evidence that made the uncontroverted medical opinion logically insupportable. We see it also in the Talina case, which we put before the court, because we thought we should, the foreign cases. We've explained in our written case how they're somewhat sui generis foreign cases in relation to the law, because the court has a special role there of being able to interpret law, even foreign law, it being a court.
Well, the Judicial Committee of the Privy Council discussed this particular question quite recently in a case called Perry and Lopag.
Or more my fault for not being up to date with that. Up to date with Brownlee and Lord Leggett saying, so I'm grateful, Lord.
You might want to look at it. I'm not sure it will be in any way central to submissions today.
I'm grateful, and of course we'll have a look. And certainly Lord Leggett in Brownlee sought to emphasise that there will be some circumstances in which you no longer need to have an expert at all, because a court will be able to look at a foreign statute, say, or its equivalent piece of legislation and make its own assessment.
Well, essentially what the board held was it will depend on the nature of the foreign law. If it is very analogous to English law, then the judge can bring his or her training to bear and form a view. But in that case, it was Israeli law, Israeli family law, and Liechtenstein trust law, and the board took the view that this was the rule and concurrent findings of fact applied, because I think it was Cayman Island judge did not have the skill set to make an independent judgment.
Which possibly makes sense even for the Privy Council, not to be familiar with those areas of law. My Lord, yes.
Mr. Weir, what's your submission then in relation to expert evidences to foreign law? Is it covered by the same general approach?
Not quite is what I would say. Not quite. We thought, I mean, it is what it is. It's sui generis because of this feature. We thought we should nevertheless put it before the court,
yes,
because we didn't consider it to be irrelevant. So forgive me for what may feel like an incomplete answer.
I don't think the board was departing from prior law, but was simply explaining how the various cases hung together.
Yes, my Lord. So in the AS Talina case, and I can't remember if I've invited you yet to page 718, but if I haven't, can you kindly go to page 718, 718. So 718, left-hand column in the middle. The paragraph starting, it is said that there are inconsistencies. And then if you drop down about 7 or 8 lines, the witness, however expert in the foreign law, cannot prevent the court using its common sense, and the court can reject his evidence if he says something patently absurd, and this was the passage that we put in our written case, or borrowed from that in Dicey, if it's patently absurd or something inconsistent with the rest of his evidence. We see the same thing in associated shipping, which is the more recent relevant foreign law.
Whose dictum is that?
Yes, I do apologise. I think it's Lord Justice Scott, but I'll just check. It is Scott.
It is Lord Justice Scott.
Yes, it is. Apologies, 714. And associated shipping is at page 294. This is the judgment of Lord Justice Ralph Gibson. And again, if you go right in the middle, the paragraph that starts, "It might be that a system of law."
Sorry, which page?
It's page 294, my lord.
Thank you.
294. This is considering the expert evidence of Mr. Manfield. In fact, the court says there was other expert evidence in the case, and so it can decide it on the basis of other expert evidence, but it nevertheless goes on, because at 293, just under the quote, you can see, "For my part, I'm not persuaded, even if there had been no admissible evidence other than the affidavit evidence of Mr. Manfield," and that's what it's now considering, "the court would have been compelled to accept and to act upon his evidence." And then when you go to 294, that middle paragraph, in the middle of it, in which Lord Justice Ralph Gibson says, "The court's entitled and I think obliged to use its own intelligence in assessing the evidence of an expert on foreign law," see the judgment of Justice Scott in a Tolina case, "and is not required to accept an opinion which in the court's judgment is not capable of being supported by the material on which it's said to be based." And while I'm in this, so I don't have to take you back to it, if you then kindly go to page 290, what you get is the actual conclusion, and I'll make a further submission in a moment on this, but if I just take you to it now. So if you go to 290 under the heading "Conclusion on this appeal," you'll see it says, "For my part, I would dismiss this appeal for the reasons which follow. It would be a sufficient ground, I think, to hold as I do, that the plaintiffs failed to prove by the evidence of Mr. Manfield that the DPA exists as an independent legal entity." So there you see a failure to prove conclusion. But in our respectful submission, what the analysis undertaken by Lord Justice Ralph Gibson is that's the conclusion. How he got there is by recognising that he shouldn't accept the evidence of Mr. Manfield. It's that way round. In other words, this case, like those cases, is not a case about burden of proof. As a consequence of rejecting Professor Pennington's evidence, which necessarily happened, the court can say the claimant's not discharged the burden of proving causation, because there's no evidence at that point for the claimant to prove causation, because the evidence has been rejected, in just the same way as we see in the associated shipping case, that as a consequence of not accepting the evidence, it can be said that the claimant who bears the burden in that case of proving foreign law was unable to discharge the burden of proving foreign law, that in that case DPA existed as a legal entity that could be sued, the defendant. And there's a little bit on this also in a case called Deepak Fertilizers. If you can kindly go to page 849. This is the judgment of Lord Justice Latham, and it's addressing an issue of causation, and paragraph 48, the respondents submit the judge clearly considered this aspect of the case with care.
Sorry, I've got a page.
Sorry.
Did you say 849?
Yes.
Yes, my lord.
Paragraph 48 at the bottom of the page.
849.
Oh, I'm sorry, I see what's happening.
I see, yes.
It's an internal imagination.
Yeah.
Paragraph numbering. Yes.
Yes, I'm always going to use your what I would call external paragraph page numbering.
It's just the way the page had been laid out.
Oh, I see. I'm sorry. Something's happened. submit that the judge clearly considered this aspect of the case with care due to the fact that it ultimately determined the result of the action. He was entitled to conclude he was not satisfied with the appellant's evidence on a matter in respect of which the burden of proof was on them. And this was the case, as you can see from lower down. The Respondent's counsel accepts he'd not challenged Mr. Cotwell's evidence and accordingly made no submissions to the effect that the evidence could be disbelieved or otherwise treated as unreliable. But it submitted this didn't mean the judge was obliged to accept that evidence. And then over the page, first of all, we get reference to what we call the rule in Brown and Dunn, but set out by Lord Justice Latham and referencing the relevant part of the then relevant chapter in Phipson on evidence. Then we have paragraph 50 explaining that the general rule remains a valid rule of good practice and fairness. And then at paragraph 51, at the end of the day, each case will depend upon the way in which the issue arose and was dealt with in evidence. The present case is a good example of the way unfairness can arise if a judge makes an adverse finding in the absence of a very secure basis for doing so. At the end of Mr. Cotwell's evidence, the appellants were entitled to conclude his evidence on this particular issue had been accepted by the respondents, at least to the extent it was not in dispute. That's because it wasn't cross-examined. And so the learned judge could not do what he did, which is say the claimant hadn't proven his case. That's because the learned judge was required to accept Mr. Cotwell's evidence, it not being cross-examined, on this particular issue. So the prior issue is acceptance or rejection, right or wrong, the consequence of which, if you then reject the evidence or say it's wrong, it may be, if that's the party with the burden of proof, that you can then say, like the Respondent's counsel sought to, you can say, well, they didn't discharge the burden of proof. But that is a consequential.
But that's also subject to the absurd point and you don't have to challenge something if it's so ridiculous. You can just sit down.
Incredible.
Yeah.
It seems to be the sort of ordinary word that's used. Absurd is the word that's used in, absolutely, it's in one of the foreign law cases. And essentially, that's from our perspective, a semantic issue, because it's essentially saying reverse summary judgment in a different form. So just to return, where the court was provided with a key, with an answer on the issue of causation by Professor Kennington, the only question for the court was whether to accept or reject that evidence. And at least at paragraph 1 of her judgment, it did look as if Lady Justice Aspin saw that point. If we go back to page 115, paragraph 1, first sentence. This appeal raises the question of whether, and if so, in what circumstances the court can evaluate and reject what is described as an uncontroverted expert's report. And that more accurately sets out the position, because that's the issue. Can it evaluate it, look at the quality, make its own assessment, or is it an issue of rejection? Later in her judgment, as we know, at paragraph 67, and I took you to that paragraph already at page 134, the analysis of Lady Justice Aspin is the case failed for want of discharge of burden of proof, and as a consequence of that, the evidence was rejected. But in our respectful submission, that is the wrong way round. And see the dissenting judgment of Lord Justice Bean at paragraph 96, which is page 139. Perhaps I can just invite you to turn that up and quickly have a look, but I won't read it out.
Sorry,
it's para 96, page 139, my lord. 139. So can I then turn to our second heading, which is the rule in Brown and Dunn is a rule of fairness of general application in civil litigation. This is obviously critical because the respondent's cases, as per the judgment of Lady Justice Aspin, the rule in Brown and Dunn does not apply in this case. And can I start with the backdrop to consideration of the rule, namely that we operate an adversarial system of civil justice. And here, can I refer the court to our written case, pages 67 to 68, paragraph 7, because I'm not going to go through each of those references, I don't have time. But if you can kindly note that we've sought to set out the relevant passages at pages 67 to 69, and the particular significance, 67 to 69, my Lord. And the particular significance of emphasising the adversarial nature of our civil justice system in this context is as follows. First, the parties control what the court decides. Put another way, decisions made by the parties affect the role the court has to play in the parties' litigation. And we can see that from our reference to Akhtar and Boland today through to our reference to the judgment of Lord Justice Dyson in the Al Medina case at D. So that in our case, by electing not to cross-examine, the defendant has impacted upon and tightly circumscribed the role of the court. This is normal. This is how the adversarial system works. The parties control it. You make admissions, you limit the issues. The court then has no jurisdiction to address matters that are not in issue between the parties. Secondly, at trial, the accuracy of evidence, not just the truth of evidence, is tested by cross-examination. And can I go to the judgment of Sir John Donaldson, Master of the Rolls in Chiltern and Saga, which is at page 837, please. 837. It's shortly put, and well put, if I might respectfully say, between B and C.
I'm so sorry, can you give me the page number?
Yes, my Lord. 837.
Thank you.
B to C. It's a case in which the district judge didn't permit cross-examination, and that did not go down because we have an adversarial system of civil justice. And between B and C, you'll see the Master of the Rolls say, we operate on an adversarial system of achieving justice, a system which can be modified by rules of court, it can be modified by contract between the parties, but in the absence of one or other, it's basically an adversarial system, and it's fundamental to that each party should be entitled to tender their own evidence, and the other party should be entitled to ask questions designed to probe the accuracy or otherwise, or the completeness or otherwise, of the evidence which has been given. And in our context, consistently with the role of cross-examination, as I will develop, the rule in Brown and Dunn applies when the accuracy, not just the truth, of a witness's evidence is challenged. It's all of a piece. Thirdly, the general rule is that conflicts of evidence are resolved at trial by cross-examination, unless the evidence is incredible. That is such that one party can obtain summary judgment inviting the court to reject such evidence on paper. And we refer to, and again I'll invite the court now please to look at, the case of Long and Farrer. If you can kindly go to page 525. 525. We're in a judgment of Mr. Justice Reimer. The context for which is paragraph 57. The registrar was dealing, I'm picking it up in the middle, an application which, subject only to an appeal, finally decided the rights of the parties with regard to the section 3661 application. It was therefore akin to a trial, albeit one of modest dimensions. It is, I believe, by now familiar law that, subject to limited exceptions, the court cannot and should not disbelieve the evidence of a witness given on paper in the absence of the cross-examination of that witness. There's then reference to a series of cases in which you can see, for instance, paragraph 6 in the judgment of Mr. Justice Chadwick, right near the bottom of the page, how it's set out in the penultimate paragraph there, except any court, and particularly the Companies Court, should not seek to resolve issues of fact without cross-examination where there is credible evidence on each side. But I do not accept the court is bound to hold there's a need for a trial in circumstances in which, on a proper understanding of the documents, the evidence asserted in the affidavits on one side is simply incredible. In other words, you can obtain summary judgment, because that's the process that we have under the civil procedure rules. Can you knock the case out on a summary judgment application even though there's witness evidence against you? Or do you have to go to a trial? And so again, over the page, at page 527, paragraph 61, the basic principle is therefore not an unqualified one. In particular, paper evidence which is manifestly incredible can be disregarded or disbelieved, but it will require a fairly extreme case for untested paper evidence to be rejected on that basis. See, after all, that which the Master of Rolls had to say in the Chiltern and Saga case about the importance of the right of the party to test evidence by cross-examination at a trial. And that, as we see and is set out in our written case, is the same distinction made in Brown and Dunn. We'll come to that in due course. The distinction is made. It's not the issue of fairness recognises that where the evidence is incredible, then cross-examination is not required. Fourthly, there must be material upon which the judge can safely reject expert evidence. And for this, if you kindly go to page 1194. 1194.
Sorry, the proposition again was...
Lord, yes. There must be material upon which a judge can safely reject expert evidence.
Sorry, the page number?
Yes, my Lord. 1194.
Okay.
1194.
But before dealing with that,
Yes, my Lord.
In the modern era, is there scope under the rules to ask focused questions of an expert? The questions that were asked in this case didn't actually raise the points that were determinative at the trial, and which were made available the night before the case came on for hearing.
My Lord, yes.
But do you have to go to the expense of actually having the witness there, rather than saying, well, this is the points I want to make to you in cross-examination, and do that on paper?
My Lord, the ordinary position, and I'm just looking at the same time in 5, the ordinary position is that questions are questions for clarification, and there's no suggestion that anything was different in this case. But you can apply, it's page 250 of the bundle, written questions to experts, rule 35.6.
Page 250?
250, my Lord. And the answer is contained in 35.62, which says, if the court has that, it's page 250. Written questions under para 1 may be put only once and must be put within 28 days and must be for the purposes only of clarification of the report, unless, in any case, the court gives permission or the other party agrees. So the answer to my Lord's question is you need to apply to the court to ask focused questions, not just for clarification, but if you like, by way of challenge.
Well, they could have focused their questions when they asked their initial questions.
Lord, yes.
Yeah.
Yes.
And didn't.
These are the powers.
Yeah.
So in Read G and B, this is the judgment of Lord Justice Wall, and paragraph 16 gives you the context for paragraph 17. In which he says that whereas here the local authority has prepared its schedule of proposed findings with some care, where the fact-finding hearing has itself been subject of a directions appointment, at which the parents had agreed not to apply for various witnesses to attend for cross-examination, it requires very good reasons, in my judgment, for the judge to depart from the schedule of proposed findings, which he recognises affects the issue of fairness, see at the bottom of paragraph 16. And then he continues, it's of course axiomatic that judges are entitled to disagree, again the language of agree, disagree, reject, accept, right, wrong, with an expert witness. But this proposition has an equally obvious corollary. There must be material upon which the judge in question can safely found his or her disagreement, and he or she must fully explain the reasons for rejecting the expert's evidence. It's the same each time in terms of this accepting or rejecting. And That is highly significant where the expert evidence is uncontroverted, because it means there is no evidence external to the expert's evidence which can provide material to allow the judge to reject the expert evidence, because that's our definition of uncontroverted that I gave at the outset of my submissions. So therefore, it has to be internal to the report, wholly internal to the report, founds the basis for rejection of the conclusion of the expert. It's the only way it can work. My next submission is that the general rule is a rule of fairness, and this can be dealt with fairly shortly. I can probably just give you the references in Brown and Dunn, unless the court would like to be taken, because I don't think I've taken you yet to Brown and Dunn. I can always go there as it's the lead case. Perhaps I should go to Brown and Dunn. Can you kindly go to page 300? Brown and Dunn, as the court will have seen, is a libel action in which the plaintiff sought to sue the solicitor who had been instructed by a number of the plaintiff's neighbours, in effect, to say he's not the best neighbour. And the plaintiff's case was that the solicitor had essentially invented the document that he produced, purporting to have been signed by the other neighbours who were disgruntled with the plaintiff's behaviour. But the plaintiff never cross-examined all of the neighbours who were called to give evidence to confirm that they had instructed the solicitor defendant to produce the document he produced. And we have two judgments or speeches to look at. First, at page 300, the then Lord Chancellor, Lord Herschel. And if you go down towards the bottom and then over the page, my lords, I've always understood, does the court have that? Right down at 300, towards very near the bottom, that if you intend to impeach a witness, you're bound whilst he's in the box to give him the opportunity of making any explanation open to him. And as it seems to me, that's not only a rule of professional practice in the conduct of the case, but is essential to fair play and fair dealing with witnesses. And that may be the language of the late 19th century, but that's what we would now just simply describe as fairness. And see per Lord Halsbury at page 306.
It's not only fair dealing with the witnesses, it's also fair dealing with the court.
Absolutely, my lord. Absolutely. So at page 306 at the bottom, the last paragraph of page 306, in the middle, Lord Halsbury says, "To my mind, nothing would be more absolutely unjust than not to cross-examine witnesses upon evidence which they've given, so as to give them notice and to give them an opportunity of explanation and an opportunity very often to defend their own character, not having given them such an opportunity to ask the jury afterwards to disbelieve what they've said, although not one question has been directed either to their credit or to the accuracy of the facts they have deposed to." We can also see this from two Privy Council.
You see there both credibility and reliability.
Oh, my lord, I do, yes.
Because you were mentioning accuracy before.
My lord,
that's there.
Accuracy is the key word. It's not just an issue of credibility, and that identification of that by my Lord the Deputy President is absolutely on point and is coming up next as well in the case of Chen and what I'm going to call Nuk. I'm not really sure. Ing.
Chen and Ing, as I understand.
Well, I'm very grateful.
I was the junior justice in that case, and I think I recall that Mr. Ing was called Mr. Ing.
I'm extremely grateful, Lord, and glad I proceeded with caution. So I can start at page 330. We're now in the joint, I think we can call them a judgment, we can, yes, judgment of Lord Neuberger and Lord Mance, if Lord Neuberger likes to be called Lord Neuberger and not another way of pronouncing his name. And if the court then goes to paragraph 53, in which the court notes that parties relies on a general rule, and I won't read it all out, save to pick it up after the reference to Lord Herschel and Brown and Dunn. In other words, where it's not made clear during or before a trial that the evidence or a significant aspect of the evidence of a witness, especially for his party proceedings, is challenged as inaccurate. See the observation by Lord Hodge. It's not appropriate, at least in the absence of further relevant facts, for that evidence then to be challenged in closing speeches or in a subsequent judgment. And then if you drop down to paragraph 54, the court explains how for an appellate court, pick it up in the middle, it appears to the board an appellate court's decision whether to uphold a trial judge's decision to reject a witness's evidence on grounds they were not put to the witness must depend on the facts of the particular case. Ultimately, it must turn on the question whether the trial, viewed overall, was fair, bearing in mind a relevant issue was decided on the basis the witness was disbelieved on grounds which were not put to him. And then we also see this in a case called DPP against Nelson, and for this, can you...
What Lord Newberger and Lord Mance are saying there is that it may depend on the facts of the particular case.
Absolutely.
As to whether or not there's been unfairness.
Absolutely.
So the rule in Brown and Dunn isn't absolute.
No, my lord.
It may be certainly at its time a general rule, but what the court is saying is you look to the facts of the particular case to assess whether unfairness has occurred, and you say, of course, in this case it has.
My lord, yes. I mean, one can obviously take a sort of easy example of a completely collateral issue, one even the judge didn't rely on, which wasn't cross-examined in a 3-day cross-examination, and it would be embarrassing for a party to complain and say, look at the rule in Brown and Dunn. There would be no unfairness that arose, and you can have at the other end of the spectrum, we would respectfully say this case. At no stage have we talked to say it's some fixed, immutable rule in that sense. The rule is there, it's a general rule. Its application to the facts of a case requires the court to address whether there has been unfairness on the facts of the case, but it doesn't affect the general rule, if I can put it that way.
Is there any case dealing with expert evidence as such?
Yes, my lord. There's an Australian case. I think Reed and Kerr deals with expert evidence, and then there is the not the Markham case, Edwards Life Science, which I'll go to, my lord, in due course.
Right, because it might be said against you, I guess, that at this point the extracts you're showing us are all about credibility or accuracy of factual statement.
Oh, yes, I'm not sure it is said against me, actually, when I look at the respondent's written case, which I'll go to in due course, and it seems to be a recognition that a challenge to the professional conduct of an expert, as far as I understand their written case, I don't mean that rudely, I mean my understanding of their written case is that they would appear to recognise that the rule in Brown and Dunn is engaged in, but even if they don't recognise it's engaged in, the Court of Appeal have said that it's engaged in, and it must be engaged in, simply put, because an issue of fairness, it shouldn't be trammelled in that way and limited to certain categories of witness. Expert witnesses are simply witnesses who give expert opinion, but they're all witnesses, and the rule applies to witnesses. Why shouldn't it if it's a rule of fairness? But I can come back to that. DPP and Nelson, page 866, please. This is a 3-judge judgment of the Privy Council, something I'm not sure I've necessarily clocked before, but evidently is something the Privy Council can do. I'm more used to the 5 than the 3, but I assume this is a full judgment as opposed to some sort of partial.
Yes, the board does, in certain cases, reduce the size of its panel,
Yes.
Depending on the importance of the issues.
It wasn't a permission. It looks like a full-blown decision on the issue as opposed to a permission case. I think it simply is that. Not only does it show that the rule in Brown and Dunn applies to criminal cases, but that doesn't really matter much for these purposes. But if you kindly go to page 866, and here we're in the judgment of Lord Hughes, you'll see the submission was made by the defendant appellant, who'd been convicted of murder, that the failure to put to him, this is para 23, that he planted the scissors sometime after the shooting, contravened the general rule, what I would call a rule in Brown and Dunn, which you can see how it's been set out at paragraph 23. And then at para 24, the board endorses this general principle. The gravamen of it is fairness. Pithy. In terms of what is this fairness and can it be broken into parts, in our respectful submission it can, and it was incredibly helpfully done in a Canadian case which we've set out. If you can kindly go to our written case at page 69, and then can I invite you to, if you like, note that the submissions I'm going to make next are essentially incorporated in writing between pages 69 and 73, paragraphs 11 to 21. Which may save you if you don't wish to record all that I'm saying orally. That's the relevant section. And we've set out the part of the judgment criminal case called Aaron Quonsar over the page at page 70. And it comes in three parts, which I'm then going to develop: fairness to the witness, fairness to the party whose witness is impeached, and fairness to what's called there the trier of fact. In other words, as per the observation of my Lord Stevens, fairness to the court. I don't think I need to take you to the actual judgment, but you can see the reference in the sidebar anyway. So if I can start with fairness to the witness, but it's pretty clear from Brown and Dunn that the court is concerned with giving the witness whose evidence is being challenged the opportunity to respond to such criticism. And that's as a matter of fairness. And I read out that passage from Lord Halsbury, which captures it very well, which is at the bottom of page 306, so I won't go back to it, which was so as to give them notice and to give them an opportunity of explanation and an opportunity very often to defend their own character. And very similar language at the bottom of page 300, which I also read out from Lord Herschel. You're bound, whilst he's in the box, to give him an opportunity of making any explanation which is open to him. And that was also captured by Lord Justice Leggett, who then was in the case called W. Nagel, at page 1353. 1353. I invite you please to turn up. 1353. This is a case in which the appellant sought to overturn the decision of the trial judge in circumstances where the appellant hadn't cross-examined the witness whose evidence the trial judge accepted on the issue. Which is why Lord Justice Leggett, para 20, says the first submission would be a difficult argument to make at the best of times. And he then says in the middle at D, I don't consider this argument even open to Pluzhnik. The case which Pluzhnik sought to advance on this appeal about the thrust of what was agreed is not a case which it pleaded or put forward at the trial, nor was this the case put to Mr. Nagel, who negotiated the oral agreement on behalf of Nagel when he was cross-examined. As the judge observed, given the passage of time, etc., it may be that Mr. Nagel could not have convincingly testified that the agreement was in one form rather than the other. He was not, however, afforded the opportunity to do so. I'm reading that part out because later I'm going to come back to this, because this is an example of the application of Brown and Dunn in a case where credibility is not the issue. Maybe want of recollection. You can see that from what the judge has said. It's not an issue of dishonesty. And then at paragraph 21, the obligation on a party to put its case in cross-examination to witness called by an opposing party is not to be taken too far. It's not, and never has been, the law that every fact asserted in evidence by a witness is deemed to be admitted unless it's challenged in cross-examination. See the observations of the court this morning. But if, on an important disputed factual issue in the proceedings, a witness called by one party gives first-hand evidence which contradicts a case which the opposing party wishes to invite the court to accept, procedural fairness requires this case should be put in cross-examination to the witness so that he has an opportunity to answer it. And we don't say that's a complete exposition of the fairness basis, but that's certainly setting out with absolute clarity the fairness of the witness aspect, and it's also put in pretty general terms which don't require it to be an issue of credibility and the like, and didn't on the facts of that case.
It might be said it extends beyond fairness to the witness, but it also extends to the fairness of the entire proceedings, because it affords the witness the opportunity to provide an explanation.
Well, look, yes, that is true. The two, they're all linked, because if your Lordship's absolutely right. If the witness provides an explanation, the court is armed with the further evidence on which it can then make the fairest decision, which otherwise it's denied it, which is part of the fairness of the court assessment. They're all interlinked. Your Lordship's right.
Potentially also, I suppose one shouldn't expand it too far, but also confidence in the justice system.
My Lord, yes. Can I then briefly return to the Chen and Ng case at page 332? 332, my Lord. 332. This is if I can put it this way, albeit at the highest level, it's a working example of the importance of giving a witness the opportunity to respond. This is a witness who was cross-examined at length. He just wasn't cross-examined on this point. And the court says at paragraph 60, it is not hard to conceive of answers which might have been available to Mr. Ng to answer the first ground, and which might have satisfied or at least mitigated the judge's concern, which is the tie-in, see the observation by Lord Lloyd Jones, between the giving of the explanation and enabling the judge to perform his or her judicial function effectively. And then at paragraph 61, you can see how, again, see the observations by Lord Hodge in relation to this is fact-sensitive. See how in this case the Privy Council approaches matters. The issue concerned was central to the whole proceedings. Neither ground which the judge gave for disbelieving Mr. Ng on that issue was put to Mr. Ng. Neither ground was referred to at the hearing at any time, save the second less significant ground had been addressed in Mr. Ng's witness statement. Neither ground was obscure or difficult, and so each could reasonably be expected to have raised in cross-examination, and it's quite possible, this is an echo of paragraph 60, that Mr. Ng would have been given believable evidence which weakened or undermined those grounds, etc. And that was a case in which the appeal was allowed on the basis that the failure to cross-examine was critical.
Yes, we see that in the Ng sentence of 62.
Yes, my Lord. There is what we would respectfully consider to be a very informative judgment of Mr. Justice Wells, which I made brief reference to earlier, in an Australian case called Reed and Kerr. It's an Australian case which the link currently, before the outcome of this court's judgment, the link to English law comes via, it's referenced in Allied Pastoral. And Allied Pastoral and other Australian cases itself referred to approvingly by the Court of Appeal in Markham and Zypher. Apart from simply looking at an Australian case, that's a link back to domestic law currently. Obviously, it would then be for this court to decide what, if anything, to do with the judgment of Mr. Justice Wells.
And what page is that judgment at?
My Lord, it starts at page 635. I'm pretty sure that's where it starts, or was that actually maybe that it? Let me have a look. Yes, it starts at 635, and for these purposes, if you can kindly go to page 641, it's put in very clean and simple terms down towards the bottom. So 4/5 of the way down, page 641. I apprehend are derived from two basic precepts designed to ensure a fair trial according to law. The first is one of common justice. No witness should be attacked, and it's of prime importance that no party and no witness should think it has happened behind his back. And that perhaps again echoes the observation of my Lord Stevens about the importance of justice being done and justice being seen to be done. And then it goes on to the fairness of the court, which again I'll read out now so we don't have to go back to it, but it's put very well. He should have a fair opportunity of meeting whatever challenge is offered to his evidence, and the substance of any testimony is to be adduced or to contradict it. The second precept is based on the practical needs of a trial under the adversary system. A judge or jury is entitled to have presented to him or them issues of fact that are well and truly joined on the evidence. There is nothing more frustrating to a tribunal of fact than to be presented with two important bodies of evidence which are inherently opposed in substance, which, because Brown and Dunn has not been observed, have not been brought into direct opposition, and serenely pass one another like two trains in the night. But it gets more poetic because he then refers, as you can see from the next heading. It's an attractive judgment, and you may enjoy reading it. The next heading, which is where he references Alexander Pope, questions whether cross-examiner is willing to wound and yet afraid to strike. And you see in the middle of that page his reference to Pope.
In this case, they didn't wound or strike.
In terms of fairness to the party calling them witness, there's no doubt that that's been articulated, because we see this in the Markham against Zeifer case at page 559. And again, if you can kindly turn that up. This is the judgment of Lord Justice Jacob. This was an extreme case in which the judge made a finding disbelieving a witness when the party on the other side didn't even ask him to disbelieve the witness. And so everything had to be reversed, taking into account the rule in Brown and Dunn. So if you go to 558, before para 50, fairness to rule in Brown and Dunn, and then you can see how Mr. Buckby, as evidence, para 50, 51 was never challenged, and then para 52, it was never even suggested his evidence was false, that the judges held it was so. And then over the page at paragraph 56, you'll see, after referencing English and Emery, which is a case about giving reasons, there's a second ground which we consider first. This is page 559. I hope I'm not going too fast. Namely, that procedural fairness not only to the parties...
Your paragraph.
56, half of 56.
56, page 559, my lord. Sorry about that. Namely, that procedural fairness not only to the parties but to the witnesses, in other words, to the parties and to the witnesses, requires if their evidence is to be disbelieved, they must be given a fair opportunity to deal with the allegation. And then you see reference to Allied Pastoral and a long quote, including a quote from Allied Pastoral, a long quote from Allied Pastoral, and then the conclusion at page 561 at paragraph 61. And that sentence that I've taken you to in Markham, Core and Zeifer was expressly approved by Lord Justice Floyd in the Edwards Life Science case. So now I'm going to ask you to leap to page 473. 473. Now this is a patent case, a patent appeal, which, as I understand it from this sort of area of law, almost necessarily involves expert evidence. It did involve expert evidence, involved a number of experts, and there was a Brown and Dunn challenge on the basis that one of the experts hadn't had put to him sufficiently the issue that turned the judge. And the outcome of the case was again interesting in terms of another case looked at on its facts, in which the Court of Appeal held, no, there isn't unfairness when you actually bore down to all the opportunities this expert had who was put on notice of the issue. He went with another expert for the same party, and between them they had ample opportunity. That's all set out at page 474, para 70. It's quite detailed, it goes over the page. So that's where Lord Justice Floyd says, I'm wholly unpersuaded the judge's decision in the present case is rendered in any way unsafe by the fact that Professor Luter was not individually challenged in cross-examination on the points to which Mr. Mead has drawn attention. And then you can see how he goes through all those points, which run through to 8 of them to explain why, on the facts of that case, that wasn't it. But that's why we say this is a case, in response to my Lord Burrows, this is the case in which Brown and Dunn was applied to expert evidence, albeit the conclusion was that there was no unfairness. But if you then kindly go back to page 473, paragraph 65, secondly, I would agree as a general matter that the rule requiring important positive evidence to be challenged is a rule which is not simply for the benefit of the witness, whose honesty or professional reliability is challenged, but is also designed to ensure that the overall fairness of the proceedings for the parties. And then he refers to that passage I've taken the court to in the Markham judgment from Lord Justice Jacob. And then, just for completeness, at 67, you'll see he says that at least part of the unfairness which the rule is intended to address is a lack of any opportunity for a witness to respond to a challenge to his evidence. And 69, this is what an appeal court does, which is has to assess whether that decision not to cross-examine has led to unfairness to the extent that the decision below should be undermined and overturned. That's how it works. And it's not sufficient for the party to be put on notice generally that the witness evidence is challenged. The party is entitled to know the nature of the challenge. And if you can then, for these purposes, please go back to 559. We're now back in the Markham, Core and Zypher case, and we're in that which is quoted from the judgment of Mr. Justice Hunt in the Allied Pastoral Australian case. So page 559, para 59. So it's page 559, para 59, in which Lord Justice Jacob refers, essentially approvingly, we say, to the decision of Mr. Justice Hunt. And if you then read the indent, the quote, it has in my experience always been a rule of professional practice that unless notice has already clearly been given of the cross-examiner's intention to rely upon such matter, it is necessary to put to an opponent's witness in cross-examination the nature of the case which is proposed to rely on in contradiction of his evidence. And then there's a further part of that judgment for which we have to go to the judgment. And here, if you can kindly go to page 620. So you have the judgment in the bundle, Allied Pastoral Judgment. And if you go to 620, you're now just a little bit on from where you were, where I've just taken you to. Where I'd taken you to. So now we're in 620. And in the second paragraph, starting a challenge to the evidence, but in the middle, there are many reasons, so I'm about, a third of the way down that paragraph, there are many reasons why it should be made clear, prior to final address and by way of cross-examination or otherwise, not only that the evidence of the witness is to be challenged, but also how it is to be challenged. Firstly, it gives the witness the opportunity to deny the challenge on oath to show his mettle under attack, so to speak, although this may often be of little value. Secondly, and far more significant, gives the party calling the witness the opportunity to call corroborative evidence, which in the absence of such a challenge is unlikely to be called. Thirdly, it gives the witness the opportunity both to explain or to qualify his own evidence in the light of the contradiction of which warning has been given, and also, if he can, to explain or qualify the other evidence upon which the challenge is to be based. And we see this also in Chen and Ng, in that it was not sufficient for Mr. Ng to know that his evidence was being challenged. He knew his evidence was being challenged, and he went into the witness box. But if you go back to page 330, paragraph 54, you'll see the approach of the Privy Council. It couldn't be taken as a clean Brown and Dunn case per the Privy Council, in that there was, say, no cross-examination. Instead, what happened is set out at 54. The judge's rejection of Mr. Ng's evidence and his reasons for rejecting the evidence don't infringe this general rule, because it was clear from the inception of the instant proceedings and throughout the trial that Mr. Ng's evidence as to the basis upon which the shares were transferred in October 2011 was rejected by Madam Chen. Indeed, he was cross-examined on the basis he was not telling the truth about this issue. The challenge is therefore more nuanced than it would if it was based on a general rule. It's based on an objection to the grounds for rejecting Mr. Ing's evidence rather than an objection to the rejection itself. So it was a very specific point that was not put to Mr. Ing. And you'll see it at paragraph 57 over the page. In the instant case to boards of review, it would not be fair to let the rejection of Mr. Ing's evidence stand, given that the two grounds upon which the judge reached his decision were not put to Mr. Ing. And so that's why fairness to the party requires notice of the specific issues that are being put to challenge the accuracy of the expert's evidence, not just the experts being challenged or not accepted. And fairness to the court, I think, has pretty much come out from the submissions which I've already made. This may seem that you have to do a little bit of extraction work, but as a simple sentence in which we say is of some value to the court because it's Privy Council level, at page 831, in the judgment of Lord Toulston in a case called Caribbean Steel against Price Waterhouse. It's not a case in which there is express reference to Brown and Dunn at all. It's literally a sentence, and the court may make of it what the court will, but we take the court to it. It's a case in which the Price Waterhouse relied upon an expert called Mr. Holland, and essentially the judge didn't accept Mr. Holland's evidence, and the Privy Council held that there was no sufficient basis for the judge's refusal to do so. And there are a number of bases for that, which are set out essentially starting at page 830-37 and going all the way through to the conclusion at paragraph 46 on 832. And in the middle of all of that, at page 831, paragraph 43, one part of the reasoning advanced by Mr. Holland was that Carib Cable would have access to the surplus by taking a contribution holiday. In his judgment, Mr. Justice Jones described this as unsound because on that scenario, the asset would be subject to a discount as an income stream over time. However, this point does not appear to have been put to Mr. Holland, and therefore the judge did not have the benefit of his response. It is a Brown and Dunn point, it's just in very condensed form.
And what conclusion?
The conclusion, my lord, as I say, it was a composite conclusion. There are a number of bases for the Privy Council saying Mr. Justice Jones has got this wrong. So it doesn't track in a sort of singular way like Chen and Ng and say it's Brown and Dunn, and that's why it's perhaps not overemphasised. It's one of a number of factors which the court wasn't satisfied. And that's why I say the court will make its own assessment as to the value to this court of that case, but we choose to put it before the court. I'm not going to take you to, I think, but I simply invite the court to note that in our case at page 72, we've referred to passages from a judgment of Mr. Justice Peter Smith in an EPI case, and the reference are all sidebarred in our judgment, in which essentially he says it's important for a judge to enable him to assess that witness's response to the other case orally by references or demeanour in the overall context of litigation. A failure to put a point should usually disentitle the point to be taken against a witness in a closing speech. And later he says it's not useful simply to leave the judge to find his own analysis of the reports of experts without the experts themselves being put to the test by cross-examination, which is another echo of this should apply also to experts. So my next big heading was that the rule is a rule of general application in civil litigation. And my first submission is, given the gravamen of the rule is fairness, it makes entire sense that it should apply generally and is not limited, for instance, challenges to a witness's credibility. After all, the need for a fair trial is of general application. And it's not obvious as a matter of good sense why a rule going to the heart of the proper operation of the adversarial system of civil justice should be restricted to discrete categories of case. nor is it obvious why it should be limited to issues such as dishonesty, when first a witness should be entitled to provide an explanation for his evidence in cross-examination, whether his evidence is being challenged on the basis it's inaccurate, as much as whether it's being challenged on the basis it's untrue. You otherwise have a fascinating scenario. The claimant calls a witness, expert or otherwise. The defendant feels obliged to say, well, I say to you, you're a liar. No, I'm not. And then the defendant sits down. So I didn't need to challenge him on the rest of his evidence. I just need to challenge him on his dishonesty. Now I'm done. It's just antithetical to the proper operation of our adversarial system of justice, in which the master roles in Chiltern makes clear, and it's re-emphasised in Chen and Ing, and it's emphasised by Lord Halsbury, I think it is, in Brown and Dunn, that it goes to the accuracy of what's being said, not just to credibility. Secondly, the party calling the witness is entitled to be put on notice of the challenge to the witness evidence, again, regardless of the basis for the challenge. And thirdly, the court is not well placed to determine whether to accept the evidence unless it's challenged by way of cross-examination, again, regardless of whether the challenge is to the truth or simply the accuracy of the evidence. In other words, what I've sought to do there is to apply the fairness principle, fairness to the witness, fairness to the party calling the witness, and fairness to the court. And seek to show that applying the three limbs of the fairness in each limb, it just does not make sense to say, oh, this is in a silo called witness of fact or in a silo called credibility. And see the approval, and I'm going to just briefly go through these, repeated approval of the general statement in Phipson on evidence by the Court of Appeal. So first of all, we have Lord Justice Bean in the court below at page 137.
That seems to have disappeared from the latest edition.
My Lord, the latest edition...
Possibly as a result of the decision of the Court of Appeal.
Well, my Lord, the 2022 starts at 1500, and at page 1505... it says requirement to challenge evidence, and Phipson on evidence, footnote that is 1505, my Lord.
You're reading from a footnote?
My Lord, I'm at 1505.
Yes.
I'm saying at the top of 12.12, do you see it says requirement to challenge evidence, and the heading has got a footnote.
Yes.
And the footnote is cited with approval in Griffiths and TUI at 87, that's Lord Justice Bean, that I was just taking the court to, my Lord. And then it says, in general, the party is required to challenge in cross-examination the evidence of any witness of the opposing party if he wishes to submit to the court that the evidence should not be accepted on that point. The rule applies in civil cases as it does in criminal. In general, the CPR does not alter the position, etc.
And how does that, where do we find the original version of it, the one that was quoted by Lord Justice Bean?
My Lord, yes, that's at page 1498.
Thank you.
That's the 2018, I think it is, version. And then there are earlier versions referred to by earlier Court of Appeal judges, which I'm just about to go to. So that's 12.12 again, my Lord.
Yep. Okay.
My learned friend makes reference to some post-Griffiths Court of Appeal cases, which I'm not going to deal with because I don't think I really need to, other than say that a first instance judge is a limit to what you can expect them to do, other than say it's a majority decision of the Court of Appeal. I better be seen to be saying I'm following it, because that's...
Yes, so the fundamental part of the quote that Lord Justice Bean founded his dissent on,
yes, my Lord,
you say remains in the 2022 edition.
Absolutely, my Lord. Yes.
The text is slightly shorter, but it's you say the point's the same.
I do, my Lord. And just to complete that...
Well, I apologise, the text may not be shorter. It goes on to talk about the function.
Oh, yes, my Lord. I didn't read it all out.
And so on, yes.
But it's all there. That it's flexible, etc.
Yeah.
I will, if I may, just take you then to page, first of all, 736. Here you're in a family case in the judgment of Lord Justice Peter Jackson, in which you'll see at paragraph 18, I mean after he's set out from paragraph 15 onwards, his identifying the importance of what he describes as putting in an adverse case, and then quoting from Chen and Ng, and then summarising it by 18, in assessing fairness, what is important is substance, not form. And then he says it's case-specific, rooted in the real world of litigation in which overall fairness can be achieved in a range of ways. In general, a party is required to challenge in cross-examination the evidence of any witness of the opposing party if he wishes to submit that the evidence should not be accepted on that point. If a party has decided not to cross-examine on a particularly important point, he'll be in difficulty in submitting the evidence should be rejected, and he references Phippson 19th edition.
That's almost word for word from Phippson.
My Lord, yes, but this bond has been put so that one can be in no doubt as to that's what the Court of Appeal is setting out. It's not just approving it, he's saying it and then referencing where it's come from, exactly its source. And the point I wish to make is see the general language in which both Lord Justice Peter Jackson and Phippson on evidence set this issue out. And similarly, we get this in the Edwards Life Science case that I've already taken you to. The reference for this is page 472. So it's page 472. Paragraph 62, in which you get the quote from the 2016 version.
Sorry, page
472, my Lord. 472. At 559. You get approval by Lord Justice Jacob in the Markham case of that which is set out by Mr. Justice Hunt in the Allied Pastoral case, and I read out the early passage at para 59, which again is put in general terms, and indeed there's reference, if you go over to 561, to a much earlier edition of Phippson, 1976.
Whereabouts?
At 561 before para 60, so second para down.
Yeah.
And I won't take you back to this, but the reference was page 1353, the judgment of Lord Justice Leggett in the Nagel and Plusnik case, because again the principle was put in general terms.
Sorry, I put page number.
My Lord, yes, this was the Nagel and Plusnik case, 1353. It was the paras 20 to 22. And indeed, we can go back and have done as far as 1820 with something called the Queen's case. And can I invite you to please have a look at this. This is at page 1098.
What year are we talking about?
1820. It starts at 1092, and the court can see at 1092 in the House of Lords, 24th of August 1820, and I will defer to this court as legal historians to understand how it is that questions could sort of be asked of the House of Lords in this way. It seemed to be a sort of question and answer session that was going on over a number of days, and your lordships will understand more about that than I do, but that seems to be what has happened here. And if you kindly go to 1098, I'm not going to read it out because it's actually quite difficult, it's tiny print, and I will get it wrong. I'm going to tell you, in essence, or make a submission as to what I say has happened here, and then invite the court to read. It's quite dense and it's quite difficult to read, especially on computers, because it's kind of going to come out nice and small. But what's happened here is they've been asked a question, and you can see this from about a third of the way down the page. So we're after October the 7th, where in the paragraph it says, first, if the court's below. And there's a question that says, if you don't ask a witness whether he'd made a declaration as to whether he remembered there'd been a quarrel, can you go off and call another witness to prove that he did know about a quarrel? And the answer is no. You've got to cross-examine him first. So that's where you get to lower down Abbott CJ, and how it says 4 lines down, the question must be answered in negative. And the point about this is that it's not being said in this context that that's because the witness is lying. Because you see, so after about 5 or 6 lines after Abbott CJ, it says that question applies itself to the time of the examination, and many things may have taken place, and conversations may have been held upon them at one season by persons of the strictest honour and integrity, which may at another season be absent from their memory, i.e. they've forgotten them. So you're duty-bound to cross-examine him before you go and call your own evidence to say, he did say this. And then it carries on. If you drop down to, now we're about 12 lines up from the bottom, do you see it says, for this reason, the proof that at a time past a witness has spoken on any subject does not, in our opinion, lead to a legitimate conclusion that such witness at the time of examination had that subject present in his memory, and to allow the proof of his former conversation to be adduced without first interrogating him to that conversation and reminding him of it would in many cases have an unfair effect upon him and upon his credit. And they say, according therefore to the practice of the courts below, etc., that you have cross-examination. And then you get a more vigorous example in terms of where you want to challenge someone on the grounds of not believing them at 1103 to 1104. And this, in our respectful submission, is an early recitation of what we now call the rule in Brown and Dunn. So bottom of 1103, we're of the opinion that according to the usage and practice of the courts below, and according to the laws administered in those courts, the proposed proof, and this is, you have to go back to the question under the heading October 19, still on page 1103. As I say, I expected it would be really hard to track all of this in court today, and easier for the court later to read it at their leisure. Practice of the courts below, and according to laws administered in courts, the proposed proof cannot be adduced without a previous cross-examination of the witness as to the matter thereof. And then over the page, you'll see how it goes on to explain why. And right down in the middle, it says, and it's quite hard to pick up, but it's before the end of that large first paragraph, so that if evidence of this sort could be adduced on the sudden and by surprise without any previous intimation to the witness or to the party producing him, great injustice might be done. So it's recognised, and I hope the court can find that. It's pretty much absolutely in the middle of the page. Injustice being obviously synonymous with issues of fairness. In Brown and Dunn, Lord Herschel had said at page 300, and although
there's an interesting comment just below the passage you referred,
yes,
where the court says one of the great objects of the course of proceeding established in our courts is the prevention of surprise, as far as practicable, upon any person who may appear therein.
My Lord, yes, it's really, in our respectful position, apposite the case. And the approach taken as far back as then. And I was just going, again, to see the flow of this. I did read this out, but I'll just go back to it at page 300. Lord Herschel, so we've now advanced ourselves all the way as far as 1894. And Lord Herschel at page 300, in the passage I'd read out, so 5 lines from the bottom, says, "My lords, I have always understood In other words, it was practice then, and we say that's the practice which was also identified in the Queen's case as being common practice then. Now, we haven't gone further back with any success, but we say it's a rule of long standing, if I can put it that way.
Depending on the precise meaning, I suppose, of the rather old-fashioned word impeach.
Well, my lord, the old-fashioned word impeach I've put in our written case is really challenge, not necessarily challenges to...
Well, that's what I was...
That's our respectful submission, my lord.
Yes, I understand.
It's not an ambiguous word. It's a word, I think, with more than one meaning, because obviously in the States, for instance, we all know about the business of impeachment. And so impeaching could have a very specific meaning in that context, but here it means challenge. And that's the language which is used. This is all in support of a broad submission I'm making, that this is a general rule that goes to the accuracy of the evidence being challenged, not just the credibility of the evidence being challenged. And that's the actual language in Chen and Ng at paragraph 53, it's 330, where the evidence is challenged as inaccurate. So both challenge and inaccurate. That's page 330, para 53. And then I made a submission earlier, obviously I'll leave my learned friend to develop his case as he sees fit. But in terms of my understanding, I would just invite the court to have a quick look at page 98. Page 98, paragraph 20. After referencing what Lord Justice Floyd said in Edward's life sentence, which obviously the respondent's having to tackle because it is the case involving the application to expert evidence, it said, clearly impugning an expert on the basis that he or she is dishonest, but that's not the part I'm referring to, it's now the next part, or in a way that it amounts to an attack on their professional liability. For an example, a challenge to, ignore integrity, a challenge to their professional competence could have serious reputational consequences, and fairness may, in those circumstances, require the point to be put to the witness. That's pretty close, if it's not, to a recognition that the rule in Brown and Dunn applies when challenging the professional competence of an expert. That's how I interpret that, but I'll leave that to the court.
Yes, you would say an attack on someone's professional competence could include an attack on their professional competence as an expert witness.
One only has to, just for one moment, my lord, imagine how Professor Pennington may be feeling about all of this, knowing that he's going to go into the law books.
Well, I suspect when he wrote the report, he never dreamed that it would be being debated in this court.
As with every piece of litigation, well, not all. Some know they're going to the top from the beginning, but with many pieces of litigation, the strangest paths that are taken, my lord, yes. So of course, one could see. And when one actually looks at the nature of the criticisms made, those are challenges to his professional competence, because they are saying, you have written, it's described as exiguous, scanty reasoning, incomplete, insufficient, and all the rest of it. What's that if that's not an attack on someone's professional competence? The next heading I have is the fourth one, is the rule is to be applied flexibly, and the court's entitled to reject expert evidence without cross-examination where the evidence is incredible. That is where the party can obtain summary judgment on the basis the opinion evidence is fanciful. This is important, this part, because what it's doing is moving from simply saying it's an issue of fairness to a workable rule that provides consistency within the civil justice system and the civil procedure rules. Now, there's no doubt that the rule needs to be applied flexibly, which of course is the case given the gravamen of the rule is fairness. I don't think I need to reference any cases, because I think we've seen from the case law that that's the position. But at the same time, it being a flexible rule, we recognise that there are limited circumstances in which the evidence does not need to be tested by way of cross-examination. And I've referenced the passage of Mr Justice Reimer and Longham Farrer, describing how where the evidence is manifestly incredible. And the importance here is this all comes together because the rule in Brown and Dunn, it's recognised, does not require cross-examination where the evidence is incredible. And the provenance of the word incredible in this context would appear to be the speech of Lord Morris, if you can kindly go to page 309. So 309, and at the end of Lord Morris's speech, so we're about 7 or 8 lines up from the bottom of his speech, he says, "But I can quite understand a case in which a story told by a witness may have been so incredible and romancing a character that the most effective cross-examination would be ask him to leave the box." So again, understand that as attractive language given in the context of its time, but what has happened is, from that has come identification of the word incredible, so that when your lordships go back to the various editions of Phipson on evidence, you'll see, as approved by the Court of Appeal repeatedly, you'll see reference to "but where it's incredible," all of which ties in with a different strand of evidence, namely the evidence of courts which are looking at a summary stage, which identify that at a summary stage you've got to let a case go to trial unless you can be satisfied at the summary stage that the evidence is incredible. So the whole thing ties up and produces a coherent system.
But coherence would also be achieved if there were 2 experts and they had a joint experts meeting and the other expert put all the points to the expert that was disbelieved. So in such circumstances, there may not be a requirement of fairness actually at the trial itself, if you've got 2 conflicting experts' reports and all the issues have been debated in the experts' meetings.
Lord, yes, that's one of the sort of ordinary advantages of if the other side chooses, if they elect to have their own expert, which they're entitled to, and in this case they simply elected not to serve the report of one expert, and then they were late in time on relying on the report of an expert. Exactly as your Lordship says, what happens is you get the narrowing of issues and the identification of issues prior to trial, and the ordinary order which is made in the Master's Corridor, say, time after time, is where matters remain in dispute between the expert, permission to both parties to call their experts at trial. Obviously, completely standard order that we obtain day after day. That's how it works. We respectfully submit that Mr. Justice Martin Spencer was right when he understood, and this is page 166, that the effect of all of this submission by the respondent was no more, no less than we could have obtained summary judgment at an earlier stage. The response from the respondent is, well, we didn't and we couldn't for whatever reasons. That's a detail, that's not the point. The point is, what's the threshold test? And so if you kindly go back to paragraph 30 in page 166 in the judgment of Mr. Justice Martin Spencer, in the present case, Professor Pennington's conclusion is said by the defendant to come so abruptly with so little reasoning, with so many issues left in the air and unresolved, that his opinion contained within that conclusion amounts to no more than bare ipse dixit. In those circumstances, it's contended that the conclusion is worthless. If that's correct, it would mean the evidence adduced by the claimant was never capable of proving his case on causation. Before the matter ever came to trial, the defendant could have applied for summary judgment on the basis the claimant's case, taken its highest, couldn't succeed. And that's right. Incredible in this context should be equated with what we reverse summary judgment. Obviously, where it's an issue that's central, if it's not an issue on which you can obtain summary judgment, that's again a detail. But looking at a case like this, where it's a one-hit wonder case, there's one issue in the case. This is the issue. That's what the respondent is saying. And there's a very good working example of this in a judgment of Mr. Justice Burse, as he then was, in a case called Cormer Inc. and Hegler Plastic. And if you can kindly go to page 347. 347. So there you can see what the case is. And over the page at 348, paragraph 1, it was a summary judgment application by the defendants. You can see that, para 1. And the real basis of the application is set out at page 351, para 16. The real, this is when Ms Justice Burr says, the second, and I should say, the real basis on which the defendants apply for summary judgment is the following. They say, as a result of the way in which the professor's opinion has been expressed in his various reports, in particular as a result of the existence of a fundamental change in his position, as the defendants see it, the court's in a position today to say that Professor Oswald's evidence as a whole is not credible. And so they seek reverse summary judgment. And then you see extended criticism of his report, which essentially goes from assessment onwards, assessment at para 19, and you can pick it up, for instance, again at 353 at the bottom at para 32. Part of Mr Silverleaf's submission is it's simply incredible for the professor to have changed his opinion in this way, etc. And para 36 at 355. Mr Silverleaf submitted this evidence in para 30 was simply incredible, and so on. And then paragraph 40 is the judge's judgment. I must say, if I take, this is page 355, I hope the court has that. I must say, if I take the professor's report at face value, I believe they can be read in the manner proposed by Mr Silverleaf, that's counsel for the defendant. Indeed, I'm not at all sure that Professor Oswald's explanation in his fifth report really faces up to the true scope of his evidence in his third and fourth reports. However, what I am sure about is I cannot say on this application, on the summary basis, and without having heard the professor in the witness box, that his evidence lacks all credibility. No matter how much I may doubt the professor's faced up to the problems with his evidence, I'm quite satisfied it would not be right for me to rule out on a summary application his evidence is so doubtful as to lack all credibility. For that reason, I will not accede to the defendant's application. Now, credible, converse, incredible. So it's the same credible, incredible assessment. And you've got to go a long way. It's got to be fanciful with no real prospect of success before you knock it out on paper. Otherwise, the golden rule, see the Master of the Rolls in the Chiltern Saga case, the golden rule is if you want to challenge that evidence, you test it by cross-examination. And that's why Lord Justice Clark in Cooper's Paean, in the passage I'd read out to you earlier, paragraph 42, the reference for which was page 341, said it was difficult to envisage rejecting expert evidence which essentially was uncontroverted. He wasn't saying it's difficult to envisage in circumstances where he must know that reasoning of experts is always up for grabs. It's, I think we say in our written case, it's the meat and drink upon which we thrive whenever we're actually allowed to go to court and to cross-examine a witness. That's what we do. We're always challenging their reasoning. It's normal conduct at trial to challenge the reasoning of an expert. It's the first place and ordinarily the last place that we go. So it wouldn't have been difficult for Lord Justice Clark to envisage that the reasoning would be capable of being criticised. What it does do is chime with, you can only be rejecting it where it is, using the language of Mr. Justice Chadwick in one of those company law cases, it's manifestly incredible. I then move on to the last limb. So that's our case in relation to that is how the rule in Brown and Dunn operates. That's its scope.
You're not, I think, in any of this challenging the sort of ipsy-dixit opinion.
My Lord, no,
There's
I think
example
it was
where there might not have to be cross-examination.
My Lord, no,
You just, I think, as I understand your case, say that doesn't apply in this case.
My Lord, yes, that is right. I'm just trying
An
to.
ipsy-dixit may not show credibility or incredibility at all, but the fact that it's unsupported by any reasoning is, I think, quite a well-established ground for
Yes,
not being stuck with it.
yes, my Lord. Para 84 at page 90. We may not say ipsa dixit, but essentially we're saying, because that's where we say where Lady Justice Aspin seeks to suggest at paragraph 65 that the court would be a rubber stamp if it just simply rubber stamped a report supported by nonsense, and for nonsense you could read by nothing. And we accept that if it's supported by nonsense or nothing, then applying Brown and Dunn, that report would be using the language of Brown and Dunn incredible. And that's because we've got to apply this test with the good sense of the court as a test based upon fairness. So we don't say there's some sort of outcome which is contrary to that principle at all. So far as concerns this next section, it's the rule in Brown and Dunn applies to this case, and fairness requires the court should accept the opinion evidence of Professor Pennington. And can I take that in stages? The first stage is the rule applied squarely to this case. So Professor Pennington's evidence went to the central issue in the case, that of causation. There was no expert or other evidence to contradict his opinion evidence. So it's not even a case like Chen and Ng, where he was cross-examined and the complaint is he was not cross-examined sufficiently. Rather, he was not cross-examined at all. In circumstances where the default position was that he would have had to attend trial for cross-examination if requested to do so, and that's a quote from Lord Justice Bean, if you kindly go to page 138. So 138, paragraph 89. Para 89. Second sentence, the default position was that the witnesses would have to attend for cross-examination if requested to do so, and where the respondent has not at any stage suggested that it would not have obtained an order for Professor Pennington's attendance had it made this request. It never heard or read that submission. And where, see Chen and Ng, the criticisms made of his evidence were on points that Professor Pennington could have been expected to have had a cogent response to in the courtroom. Or recall how in Chen and Ng, and it may want to just briefly turn this up again at page 332, 332, paras 60 and 61, highly relevant to the court's assessment, is can the court, using the language of paragraph 60, conceive of answers?
So this is, what's the source of this point?
My lord, it's Chen and Ng, para 60 and para 61, page 332, in which the Privy Council considered it highly pertinent to ask itself the question, because we're dealing with fairness, it'd be hopeless if we produce an artificial construct when everyone knows that there was never going to be an answer to it, and it would have taken the court nowhere. But what the court's doing in that case is saying, well, hold on, it's not hard to conceive of answers which might have been available to Mr. Ng to answer the first ground. And it repeats that in different language at para 61 brackets 5, when it says it's quite possible that Mr. Ng would have given believable evidence which weakened or undermined those grounds. Well, here, and I'm going to go to the detail, I haven't yet taken you into the depths of the report itself, but I'm rather going to take it that the court has had an opportunity to read it. It's not a long report, I think we can agree on that, to read the report. But the court will be able to see from that, here is a microbiologist, expert in his field, and it's not difficult to see when identifying the questions or criticisms which have been made by the respondent, converting them into questions. So, for instance, this can be done by reference to the SFI. If the court kindly goes to page 55, para 25 of the SFI, page 55. the court will see that these were the alleged deficiencies, which were summarised by the Court of Appeal, and you see we've put them out at 1 to 5. And if you look at those and now convert them into questions, it's not difficult to see how if Professor Pennington is asked, why have you said no more about the possibility of 2 separate infections, that he would have an answer to it. It's his field. And ditto when you look at the next set of issues.
And what was the answer? And what would be the answer that we conceive of in relation to that?
Well, my Lord, in relation to the stating that two separate infections couldn't be ruled out, having said no more about it and not explained why the meal might not be at fault for the second episode, there's quite a lot to say about that, which I have to sort of take in stages by going back to his report. But
well, in relation to the latter point about the meal, he made quite clear it was the frequency of dining at the hotel. If it's a thin case and you eat over several days in one place and eat once somewhere else, then the likelihood points
my Lord,
towards where you've eaten repeatedly.
Just so, at a time when he didn't feel well, and I think I'm just rooting around for his witness statement, because it's a time when he didn't feel well, and he didn't even sort of eat that much. He ate half of it. Len Jr.'s saying it's somewhere in his. Here it is. Where is it? Have you got the meal? The 7th witness statement from him. Anyway, it's in his witness statement. Forgive me, and it's probably in the SFI. So just so, and he addresses why it's possible but not probable that there weren't separate infections on a statistical basis, because it's unlikely that there would be 2 infections.
Paragraph 6 of the SFI.
Paragraph 6. I'm very grateful. Yes, exactly. So it's agreed that he ordered a meal but couldn't eat much because he didn't have much appetite. So
it's page 1572, paragraph 48 of his witness statement.
Well, I'm going to sit down, my Lord. I'm extremely grateful for helping me with that.
Planet UK restaurant. I ordered a meal but couldn't eat much of it as I didn't have much of an appetite.
My Lord, yes. So in other words, he didn't go in and have the free buffet, eat all you can meal for 3 hours. He ate a little bit of food there. And it's not difficult to see in those circumstances how, having eaten all of his food at the restaurant, at the hotel before, and taken his drink at the hotel before, that should be the source, the expert. So the submission that I'm making is, this is a case in which applying that encouragement from Chen and Ing to consider whether or not it's possible or liable or likely to be questions on which the expert could give valuable answers or explanation, of course he could. In other words, the rule applies squarely to this case. Secondly, the appellant was not relevantly on notice of how Professor Pennington's evidence would be challenged until the day of trial. Now, this ties in with the submissions that I've already made, because he was not on notice of the nature of the challenge to Professor Pennington's evidence with the level of specificity as required in Chen and Ing until receipt of the trial skeleton argument the night before trial. It's not enough, as the respondent says, to identify, as is the case, if you go to page 1609, 1609, this is the appellant's pre-trial checklist, and under the heading experts, at 1609, pre-trial checklist, C experts, reference to 3 experts, and then you'll see in the 4th column to the right, is report agreed, all ticked no, as opposed to yes. But if I'd been asked pre-litigation of this case, should I tick the box agreed or not agreed, I would certainly hesitate before ticking the box as agreed when the other side hasn't written to say in terms your report is agreed. In the light of the judgment that the court will give in this case. It may be, if it favours the appellant's analysis, then where it's known that the respondent is not seeking to challenge the evidence by cross-examination, it may or may not be in this box-ticking exercise that the appellant should say, therefore the report's agreed, because they've indicated to me that they're not seeking to challenge it by way of cross-examination. But this box-ticking...
There's a difference between agreed to be admitted in evidence and agreed as to the result.
It's that's right, my lord. It's a box in which it's not entirely straightforward, is what I'm saying, to know what to do with it. Yeah. And at that stage, Professor Pennington hadn't produced his Part 35 responses. So what happened instead is, if you take the issue of the Burger King meal is the meal at Birmingham International Airport. But of course, it wasn't the only meal. For some reason, there was a fixation on the Burger King meal, but of course, the claimant, like anyone, was busy eating all the way until he went to his holiday. He was eating in the days and weeks, all the rest of it, up to his holiday, including a Burger King meal at the hotel, at the airport. This was evidently an important factor for the judge, because we can see this in two paragraphs at page 178, paragraph 19. Pretty much in the middle. The report makes no specific mention of the food the claimant ate at the airport before reaching the hotel. And paragraph 29, which is a mixture of pages 181 and 182. You have to go at the bottom of 181. They certainly don't provide me with sufficient information to be able to say that there's a clear train of logic between, for example, the incubation periods and the onset of illness, so that the pre-flight meal can be excluded, etc. That's the Burger King meal. Now, there were Part 35 questions, but we respectfully submit that the question which you'll find at page 210, question 6, was clearly a question about the meal on the 7th of August rather than about any pre-holiday meals. So page 210, paragraph 6. If the court finds as a fact, now first of all, of course, the claimant ate as a finding of fact before he went on holiday. So the if would be otiose in that context. So the issue was about whether he ate whilst on holiday, and hence the expression also ate outside of the hotel. And it makes complete sense when you're looking at whilst on holiday, and no sense if you're looking at before holiday. So that was not a question about pre-holiday eating, which of course he was doing. So there was no identification of this issue before the skeleton argument the night before trial. And as a matter of fairness, Professor Pennington should have been given the opportunity to respond to the criticism made that he didn't expressly refer to this meal or take it into account. Which of course he did, impliedly, because he read the witness evidence of the claimant. And it's fairly obvious, again, if we're looking at the, can one envisage an answer to this, how he might be expected to have answered it, because by this stage he's identified Giardia as the cause. And Giardia is associated with countries where hygiene and sanitation are poor. And I do not mean this disrespectfully if I say that includes Turkey, but I'm referring here to a document produced by the respondent and shown to Professor Pennington, which is at page 217 to 18, which has a table. And the table puts Turkey, 218, as the 5th most likely, if I can put it that way, or it says top 10 countries of travel for travel-associated cases of Giardia, and Turkey is 5th. Whereas if Giardia had been active in a Burger King restaurant in Birmingham International Airport, one might expect to have known about that, because 2, there would surely be an awful lot of people infected It's just a fairly ordinary assessment that you can expect to be made in response to that assessment. So that in our respectful submission...
What are the factors, what are the numbers representing there in that chart?
I think numbers of people for whom it's been recorded, my Lord. I think those are people. 51 people went to India in 2014 and have reported somehow that the public health have identified this data, picked it up. This page 212, you can see it's Public Health England document.
What's the relevance of this document to the trial which in fact occurred?
It was provided by the respondent as part of a CPR question, which you can see at page...
They asked questions, had he taken account of certain documents?
Yes, my Lord.
But none of this was explored.
No, my Lord, absolutely.
So...
I'm only addressing at this point the sort of, is it credible that he might have had a response? Yes, it's credible, because he's identified a hotel where there are complaints about sanitation in a country recognised to be a problem country, if I can put it, if that's not rude, a problem country in relation to infection with Giardia, which is the source, per his evidence, of the infection for this client, as opposed to the UK Burger King in an airport, which, if that's got a problem, we've all got a problem. We know about it. The number of people who must go through the airport, and not expect that would be a live issue without there being some reporting on it. So that's why...
Except you are also relying on the evidence of the expert that it's sporadic, and even if there were problems in the hotel, one person might get ill and no one else does.
My Lord, yes, but I think it's not for me to give the evidence, my Lord. No. But the numbers, if one think about numbers of Burger King meals at an airport, it's going to be extraordinarily high. It's not like the number of people who stay in a hotel for 2 weeks. Just an extraordinary number of people will go through these very popular restaurants. But it's not my job to give evidence on these issues, my Lord. But that's why, my Lords, we respectfully say that Lord Justice Bean was correct to describe this as a case as involving, his words, litigation by ambush. It's paragraph 99 at page 140. When he says the courts should not allow litigation by ambush. Third submission I have to make, my Lords, is that the expert opinion of Professor Pennington was not incredible. I think I've made this submission already. If I haven't, I'll make it again. The respondent has not suggested that it could have obtained reverse summary judgment. It's not even suggested that the opinion evidence was wrong. That's because it's careful to limit itself to an argument based upon the appellant not discharging the burden of proof. That's their written case in quite a few places, but amongst others, I think at page 98, paragraph 21. It's because they're so keen to say the rule of Brown and Dunn isn't engaged. So to do that, they have a dance to make, which is to say, we don't say the report's wrong, we don't say we can get reverse summary judgment, we just say the judge was entitled to say that the burden of proof has not been discharged. And that's why I sought to address that right at the outset. Now, one can imagine expert opinion which could be shown on paper to be wrong. Say, for instance, that Professor Pennington has said the incubation period for Giardia is 20 days, and say there was a public health document that also put down it was 20 days. So there could be really no doubt. It wasn't like he'd written 20 days meaning 2 days. It's absolutely crystal clear it's 20 days, and then the claimant's ill within 2 days of arrival. That's like the Woolley and Essex case. That's where something's gone wrong. But that's not the position. And that's why the criticism here is speculative, in that the judge identified potential flaws in his reasoning. See her judgment at paragraphs 18 to 22, pages 178 to 179, all of which could and should have been explored in cross-examination, thereby, as a matter of fairness, giving Professor Pennington the opportunity to respond, not taking the claimant by ambush, and giving the court, as per the submission which I've already made, the opportunity to hear his evidence and so determine the case on a fair basis. And this case illustrates very well, in our respectful submission, why a party needs to, what we call, pay the price of cross-examination, which involves not only putting questions to the witness, but also allowing the witness, using the language of Lord Halsbury and Brown and Dunn, and it was page 306, an opportunity of explanation. It's a very attractive phrase. An opportunity of explanation. Because otherwise the court is condoning the respondent's practice of being willing to wound and yet afraid to strike. Fourthly, in any event, there was a clear chain of reasoning. And here I'm not going to rehearse all of what we set out in our written case. I don't think it would be advantageous, but I'm going to certainly take you back to it to identify it again, please. If you can kindly go to page 85. And it's really paragraphs 71 through to 73, so it's 85 to 87. And there was an answer from the expert to reply 4, or to question 4, sorry. There was an answer, reply 4, which actually you can see at page 232. In which he says, regarding causation, etc., the appropriate experts, it's put in this generic way because the question was generic, would consider the gastroenteritis symptoms, their possible infective cause, the commonness of possible microbial causes in Turkey and their modes of transmission, their incubation periods, and the length of time the claimant had been at the hotel. I did the same. And you can actually track that through his report, and that's what we've sought to set out at paras 72 and following. We refer at 72 to how the learned judge in the High Court, Mr. Justice Martin Spencer, accepted that he took those steps, and in a little more detail, as you see from paras 73, and we'd simply invite you to read that, but I don't think it's advantageous at this level of court to grind through that level of detail other than in writing. We invite you in due course, please, to see how we can seek to show that that's exactly what's done. That is a chain of reasoning. And also, if you then go kindly to page 87, paragraph 77, right at the bottom, where it says, taking these alleged deficiencies in turn, these are the criticisms that were made, as summarised in the SFI in the paragraph I took you to earlier. That was paragraph 25 at page 55. Those 5 criticisms, again, we've sought to respond to them at page 88 and just into page 89. And those responses I'm going very slightly to enlarge upon orally, and it may or may not be that that's a convenient time for my lord.
Yes. That's fine. Mr. Weir, the court will adjourn at this point.